Okay, guys, good morning. Are we ready?
Yes, we should be ready.
Good morning. We're ready when you are.
Thank you. Okay, good morning. I'd like to call this public hearing of the Committee on Health to order. Today is Wednesday, July 10th, 2024. The time is 9:30 a.m. I'm at-large Councilmember Christina Henderson, Chair of the Committee on Health. Given street closures around the John A. Wilson Building today due to the NATO summit, this is a virtual hearing with public and government witnesses testifying through the Zoom internet platform. This hearing is also available to stream on the DC Council website as well as my YouTube page, www.youtube.com/@CMC Henderson. At today's hearing, we will consider two mayoral nominations to health professional licensing boards, as well as one bill under the committee's purview, Bill 25-672, the Radiation Protection Act of 2024. If you are tuning in hopes of hearing more about a dental specialty bill, that bill has been withdrawn by the executive. So today we will start with the nominations before the hearing, before hearing testimony on the bill. Um, all right. So in terms of the nominees, we will consider one nomination to the Board of Social Work. The Board of Social Work regulates the practice of social work in DC, including specialties within the profession. The board includes 5 members, a licensed independent social worker, a licensed independent clinical social worker, and a licensed graduate social worker, and a licensed social work associate, as well as a consumer member. PR 25-808 nominates Celeria Moore for reappointment as the consumer member of the Board of Social Work for a term to end March 3rd, 2026. Ms. Moore is an adjunct professor at Trinity Washington University, an early child education tester, and a manager of education services at DC Public Schools. She holds a master's in child development from Texas Southern University and a certificate of advanced graduate studies in staff development education from Regent University, and she is a Ward 4 resident. There is also one nomination for the Board of Dietetics and Nutrition. The board is comprised of 5 members appointed by the mayor, including 4 licensed dietitians or licensed nutritionists, and 1 consumer member who is not a dietitian or nutritionist. PR 25-0831 nominates Emily Arkin for appointment as a dietitian licensed in the district for a term to end March 12, 2025. Ms. Arkin is a registered dietitian nutritionist based in the district, and her group practice specializes in eating disorders and medical nutrition therapy for gastrointestinal disorders and other illnesses across life stages. She earned her Master of Science in Nutrition and Public Health at Columbia University and is a Ward for resident. I don't see any of my colleagues who have joined, but if they do, we will certainly turn to them. But I'm going to call on the nominees to present their testimonies. Before you all begin, if you could, I need to swear you in under oath. So if you could raise your right hand so we can see it within the Zoom box. Do you swear or affirm under penalty of law that the testimony you're about to provide to the Council of the District of Columbia in this committee is the truth, the whole truth, and nothing but the truth?
I do.
Great. Ms. Moore, why don't you go first?
Good morning. Councilmember Henderson, let me start off by saying I'm retired from DC Public Schools. Just one for the record. But thank you to the members of the committee and the staff on the Committee on Health. I am Celeria O'Moore, and it is my pleasure to receive your consideration for my nomination to serve as the consumer or public member on the Board of Social Work. I am grateful to Mayor Muriel E. Bowser for nominating me and honored to have this opportunity to continue to serve the residents of our District of Columbia across all 8 wards. I have been a resident of the District of Columbia for 39 years and a resident of the DMV for 48 years. From my earliest memories growing up in Baton Rouge, Louisiana, I witnessed my parents advocate for residents of our community. As a result, for over 40 years, professionally and personally, I have served and advocated for all members of the communities where I resided. I have worked with and for individuals with different teen abilities, including typically developing individuals ages birth to 40 plus years and their families, serving as an advocate for them, whether as a member of multidisciplinary teams or individually. All of my life and professional experiences collaborating with social workers, physicians, psychiatrists, psychologists, attorneys, and other educators have prepared me for the role of a public or consumer member as the voice of citizens of the District of Columbia on the Board of Social Work. Additionally, my ability to listen to all points of view to solve challenges and make critical decisions makes me an excellent addition to the Board of Social Work. My experiences as a member of the Board of Social Work prior to and during the pandemic have increased my perspective regarding the importance of a public voice on licensing boards. Keeping all viewpoints in the forefront, I have continued to provide guidance and responses based on what is best for our residents. Listening to members of other social work boards from across the United States and Canada discuss their challenges, I have been grateful that as a board, our government officials are accessible and open to dialogue with the District of Columbia board members regarding current and future legislation. One important change as a result of the pandemic has been implementation of hybrid board meetings. This meeting format has increased opportunities for the public to attend and participate in the board's open sessions without having to leave their work sites. It is my desire to continue my professional experiences to inform, which would be my contribution to the Board of Social Work regarding the protection and what is best for the residents and in the best interest of the residents of the District of Columbia. Again, thank you, Councilmember Henderson, for the opportunity to testify before the District of Columbia's Committee on Health. I'm happy to respond to questions from you and any other members of the committee.
Awesome. Thank you so much, Ms. Moore. Ms. Arkin?
Good morning, Chairperson Henderson and members of the committee. My name is Emily Arkin, and it's my pleasure to receive your consideration for my nomination to serve on the DC Board of Dietetics and Nutrition. Grateful to Mayor Muriel E. Bowser for nominating me and honored to have this opportunity to serve the residents of our district. As you mentioned, I'm a registered dietitian, and I've worked in the District of Columbia for the entirety of my career. In that time, I've served as the Professional Development Committee Chair for the DC Metro Academy of Nutrition and Dietetics, and also volunteered my time with the food-based organization Food and Friends. I've established my private practice in DC and grown it to a group practice that employs other dietitians. In that group practice, we provide medical nutrition therapy to clients with eating disorders, gastrointestinal disorders, diabetes, and various other conditions. I've gone through the DC dietetic licensing process myself, and I've helped my employees navigate it. I've also learned firsthand from my clients that harmful nutrition information is commonly disseminated by non-licensed providers. And as such, I have a vested interest in upholding the district's licensing standards in order to protect the public from unqualified entities and ensure a minimum quality of care by the area's dietitians and nutritionists. I applaud the board's recent move to online licensing applications. However, the District of Columbia lags behind many states in terms of how long it takes to process those applications, which can be greater than 3 months in my observation. I'd like to explore what can be done to expedite that processing. If confirmed, I would also like to recommend DC enter into the new Interstate Compact for Dietetic Licensure. In addition to approving providers for licensure, I'd also like to see the board play a more active role in identifying individuals who offer medical nutrition therapy without a license. In my experience, nutrition is a scope of practice that's often disregarded by unqualified practitioners who share inaccurate and harmful information with unknowing patients. And it's only come to my attention recently that the public can report providers practicing outside their scope to the board, but the instructions for this are embedded so deeply in the website, and they call for mail-in written letters, which could certainly act as a deterrent. The Academy of Nutrition and Dietetics has employed a recent change to require a master's degree starting this year for new dietitians. And so we may anticipate fewer dietitians of color and marginalized identities entering the profession over the next few years. This may require the board to consider new or additional continuing education requirements for licensure maintenance in order to make sure that our nutrition professionals are equipped to serve the diverse residents of the district. These are the issues I would like to take on with the other board members if concerned. Thank you, Chairperson Henderson, for the opportunity to testify before this committee, and I'd be happy to respond to questions from you or any other members.
Thank you. Thank you both. And first, let me say thank you so much for your willingness to serve. It's my PSA that I give for all of the hearings. We have 19 health professional boards. We always have vacancies. And so we need folks from the workforce and as well as consumer members to give of their time to serve their fellow residents in this way. So thank you so much for your willingness to serve. I do have a few questions. Ms. Moore, your nomination is a reappointment. And I'm just curious in terms of the last term that you had on the Board of Social Work, were there any highlights from your experience serving before?
Well, I think the main highlights that I would say from serving the board is the commitment actually that all of the members have to ensure that no harm comes to any member of the public, of our residents, by practitioners. Another highlight had to do with and this has to do, it was very interesting, and it has to do with returning citizens who have gone to universities, passed the licensing exam, who are coming back to become licensed social workers in the District of Columbia. That was a highlight because of the fact that we were able, and they were able to, many of them, to receive their license and to become really productive and helpful residents of the District of Columbia. So that was one of the highlights, and really meeting other persons who are consumer or public members on boards of social work was also a highlight for me because it really helped to highlight how really advanced the District of Columbia is in terms of policy and in terms of, as I said before, access to our government officials. So those would be my highlights.
Great. If you had to pick a issue that you feel like is the largest facing the Board of Social Work, what would you say that is?
Well, I would say that it's the same issue that is facing boards across the United States, and that is the issue of licensure, of the issue of compacts. Those would be the primary issues that are now facing the Board of Social Work, not only here in the District of Columbia, but throughout the United States.
Okay. Yeah, speaking on the licensure piece, as you know, there has been a lot of conversation and talk about the licensure exam for social work and whether or not there's bias within it and whether or not it should continue. In Maryland, they have been engaged in sort of a months-long process to sort of evaluate I guess how to proceed rather, like in terms of do you continue with the ASWB's exam and what does that look like? Even so much so that they've extended the task force that they set up to have these conversations. Do you feel like that's something that the District of Columbia should be engaged in and sort of setting up this, I guess, separate task force to have this, I would say, larger conversation around the licensure exam?
I think it should be a larger conversation. And I do realize that Virginia has said no in terms of that, and that Maryland is in discussion and talking to colleagues in Maryland. And so, yes, I think that would be important to do that. I would like to say that as the public or consumer member of the board, my concern would be the safety that no member of the public would experience harm. That even though I know that a licensed social worker would supervise these individuals, sometimes you aren't there all the time when in the supervision. And that would be my only concern. That's my major concern about that. And one other thing I want to say too is that I'm sure that the council is aware that there are African Americans who write some of those questions for the ASWB exam, and that ASWB right now actually is re-evaluating and looking at how to make changes to that exam. So yes, to answer your question, yes, I think a broader discussion is needed.
Thank you. Ms. Arkin, you haven't been on the board before, but again, always appreciate the willingness of folks to serve. We recently changed the scope of practice for dietetics and nutritionists under the Health Occupations Revision General Amendment Act, or better known as the HORA, earlier this year. So dietetics now includes the full scope of practice of nutrition, as well as other dietitian specific competencies. Do you expect any changes to the work of the board based on these updated scopes of work?
I might be misunderstanding, but my impression was that there was some discussion about merging sort of the definitions of nutritionist and dietitian, and that ended up not happening.
Okay. Perhaps this is I'm poorly reading the question that was provided to me. Let me ask you a different question. You talked a little bit in your testimony around the reporting or the lack of the public being aware of the process for submitting a complaint if you have an issue with a particular member of the health workforce. Can you say a little bit more about what you hope to improve? This has been something we've been having a lot of conversations with DC Health about, whereas like there's not even a centralized website. There's like an email address and you just got to hope that somebody read it. What are your thoughts on that?
Yeah, I was originally planning to come in today and, say that one of my goals would be to encourage that there be some kind of reporting system housed within the board website, and then found out, literally saying in the last 48 hours, that there is in fact a link on the website, but it's so far down, you really have to dig for it. And then when you follow that link, it just has a physical mailing address where you can send written complaints. And I think in this day and age, whether it's centralized amongst all the health professions or, housed on each individual licensing board's website, I think finding that reporting tool needs to be much easier for the public. And I think that the process for reporting should be digitized. Not many people are going to whip out a pad and a pen and start, writing out something to send in just in the hopes that maybe it gets investigated. So I think knowing that there's some basis for it already being there, I would really like to see improvements to the website just to make that more user-friendly. And I think that could extend to a lot of other features of the website as well. When you first go on, there's all of this kind of very general health department information that's not actually specific to the Board of Dietetics and Nutrition. And anyone who is, applying for licensure, re-upping licensure, trying to figure out what the steps are, or, reporting providers, they're having to really, really dig to get that information.
Yeah, I agree with you. I mean, I feel like DC government has been engaged in this like so-called website redesign for like forever and a day. But it seems to me as though when it comes to the health professional licensing boards, there should sort of be like two different tracks. One for public consumer members who you might want to report a complaint. You might be looking for the directory of something that happened, et cetera. And then those for the workforce, which would include all of the application materials about licensure, renewals, et cetera. So that, I often think that, we get the numbers every year of like the number of complaints that we receive per like profession. And I think that it's probably severely underreported because people don't know how to like go through the process. And it sucks because if you've had I would say, what you feel like is a very unprofessional interaction with a health professional, and then you get so frustrated, you just leave that health professional, but you don't report it, then it doesn't solve the problem. And someone else might have that same experience in the future.
Yeah, and I think if there were a streamlined way of going about that, even if I were hearing about clients' experiences secondhand, I would send them that link. I would say, just for your consideration, like if you feel strongly about it, here's where you can report somebody. But until recently, I didn't even know that that existed within the board's website.
Yeah. I think specifically in terms of dietetics and nutrition, what are your thoughts around sort of this rise of people, um, quote unquote, considering themselves like homegrown nutritionists and dietitians, on TikTok and other social media sites? Um, Interestingly enough, we had this conversation with some nominees to the board of dentistry because there has been this ongoing like number of people who have said, oh, I can do your veneers for you, even though they've never actually been to dental school. They're not licensed, all those different types of things. How would we go about how should we go about raising public awareness around dietetics and nutrition where people just assume that, oh, anyone can do what you do?
Mhm. Yeah, I mean, I think that's a huge problem in part because, social media crosses state lines. And so it's hard to always kind of the folks that we might see are kind of overstepping those bounds are not always in the District of Columbia. We might not have jurisdiction there. But I think kind of similar to the idea of revamping the Board of Dietetic and Nutrition's website, like certainly there should be some consumer information there about like what does LD mean? What is a qualified nutrition professional? What kind of schooling or accredited program should they have come from so that people can, vet those potential providers. As a private practice owner, that's something that I have on the FAQ part of my website, just so that people understand when I have these letters after my name, this is what that means. Because otherwise, fancy letters just look like that. And if you did a weekend workshop and you printed off a certificate, you could also claim that you have letters after your name. And so I think there's not really enough easily accessible information out there about kind of what constitutes a fully licensed and accredited professional.
You mentioned a little bit in your testimony around the national board changing some of the credential requirements in order. Now they require a master's degree. How do you think the district should approach that? I guess this is something you want to talk about when you're on the board with your fellow colleagues.
Yeah, so starting in 2024, anyone sitting for the registered dietitian credentialing exam needs to have a master's degree. That's going to be sort of a prerequisite to sitting for the exam. And so, on the one hand, that means that candidates are going to come in with more experience and more educational background. But I think that also really raises the financial barriers to entering this profession. We are historically a overwhelmingly white, affluent female profession. I think the percentage of Black dietitians in our ranks is like 3%, and I don't think that this is going to help that. And so when we have population in the district that's as diverse as it is, it really kind of begs the question: if the sort of if the demographics within the nutrition and dietetics profession remain stagnant, do we want to consider additional continuing education that would help meet that gap a little bit, whether it's in terms of topics related to cultural humility or working with specialty populations or that sort of thing?
Ms. Moore, you are familiar with the time commitment for the board. You feel confident that you'll be able to continue to serve and meet those time commitments? Yes?
Yes, I will
Okay.
be able to.
All right. And Ms. Arkin, has DC Health talked to you about the time commitment for serving on the board, and you feel confident in your ability to do so?
Yes.
Great. Okay. I don't have any other further questions for you guys. Is there anything that I didn't ask you that you want to make sure that we know for the record?
No, just thank you for the opportunity.
I think the last thing that I would add is just for any, council members or staff who might be kind of watching in on this, the interstate compact for dietetic licensure is kind of on the move. I think they have 3 states signed on now and need 7 to sort of create it more officially. And so that may be something that kind of comes across the legislative halls of DC at some point if there's support for it. And given that the District of Columbia is so transient. People come and they go and they come back. I just wanted to say that my personal opinion is that joining that compact could be really important for offering continuity of care for residents of the district who go to other states and then return.
Yeah. Compacts have been an ongoing conversation for us in lots of the different professions, not just the compacts, but also reciprocity agreements to try to make it easier for folks who practice both in Maryland and Virginia. The biggest problem, of course, is, well, there are any number of pros and cons to both situations. The biggest issue for in our particular region is that Virginia's requirements are so different from DC and Maryland. And so there's always a negotiation that has to take place on some of those things. But your point is very well taken.
Yeah. If it helps to know that the compact is not available to states that don't have licensure standards. And so Virginia is not eligible to join.
Oh, well, there you go. Okay. All right. Well, thank you guys again. Thank you for your willingness to serve. We appreciate your service. If any members of the public would like to submit statements on these nominees, the record will remain open until noon tomorrow, July 11th, so that they may be voted on at the committee markup at 3 p.m. You may submit written statements via the council's website at dccouncil.gov/hearings. Thank you all so very much.
Thank you.
Okay, so we will now turn to consider Bill 25-672, the Radiation Protection Act of 2024, which was introduced by Chairman Middleton on behalf of the mayor on January 26, 2024. Ms. Moore and Ms. Arkin, you guys are free to go. Okay. The bill establishes new requirements for the handling of radioactive material or waste, including radiation machines and equipment. Before I describe the specifics of this bill, I want to make sure that those watching at home understand the differences between the two types of radiation regulated in this bill. Ionizing radiation is a form of energy that acts by removing electrons from atoms and molecules of materials. Typical sources of ionizing radiation include X-rays, CT scanners, and mammography. Non-ionizing radiation differs from ionizing radiation in the way that it acts as materials like air, water, and living tissue. Examples of non-ionizing radiation are ultrasounds, sonograms, MRIs, and tanning beds. Bill 25-672 requires that any person handling radioactive material or waste or ionizing radiation machine or equipment be licensed, certified, or registered licensed in the district, and that the equipment be registered with the mayor. The bill also authorizes the mayor to issue rules related to the handling of non-ionizing radiation, including the licensure of professionals handling non-ionizing radiation machines and equipment, and the registration of non-ionizing radiation machines or equipment. The bill also authorized the mayor to establish standards for the use of both ionizing and non-ionizing radiation machines or equipment, and radioactive materials. The bill authorizes the mayor to conduct inspections of facilities and equipment licensed or registered under this act, including conducting examinations of property, tests, and inspecting records. Additionally, the bill authorizes the mayor to seize any sources of radiation or radioactive material or waste, machines, or equipment if the person handling it is not licensed or equipped with the training necessary to possess or operate it. This includes potential civil fines and criminal enforcement and penalties. Finally, the bill repeals the District of Columbia Low-Level Radioactive Waste Generator Regulatory Policy Act of 1990, which requires facilities that generate low-level radioactive waste in the district to submit an annual report to the mayor, for the mayor to compile these reports and submit an annual report to the council. I don't see any colleagues who have joined, so I'll go to public witnesses. I think we only have one public witness who signed up to testify on this bill, which is Justin Palmer from the DC Hospital Association. Justin, when you're ready.
Good morning, Person Henderson, members of the committee. My name is Justin Palmer, and I'm the Vice President for Public Policy and External Affairs for the DC Hospital Association. And I appreciate the opportunity to present testimony on the Radiation Protection Act of 2024. DCHA is the unifying voice advancing hospitals and health systems in the District of Columbia. We are committed to promoting policies and initiatives that strengthen our system of care, preserve access, eliminate disparities, and promote better health outcomes for patients and our community. Our driving vision is to achieve an efficient and effective healthcare delivery system that supports a healthy, equitable, vibrant community. Ensuring the regulation and safety of radiation generating equipment in the district is incredibly important. We support common sense regulation of this equipment and materials. In fact, our facilities are already regulated by the Department of Health as well as other entities, including the Nuclear Regulatory Commission. We do not necessarily oppose the legislation, but our members have expressed concerns, particularly regards to the required registration and licensure of non-ionizing equipment. Member hospitals believe this could include equipment such as ultrasound and sonogram machines that are prevalent throughout facilities. Any changes to the regulatory structure and regulation of additional equipment should be made in partnership with entities affected by the changes. We are unclear about what is driving the need for the changes to the existing law and regulations and would encourage the committee to convene meetings with the Department of Health and affected stakeholders together to ensure there are no unintended consequences of this legislation proceedings and ensure that the changes do not create unnecessary and increased regulatory burdens for stakeholders. Thank you for allowing me to testify today, and I'm happy to answer any questions.
Thanks, Justin. Thanks for your testimony. So one thing that stood out is that you mentioned you're not sure why DC Health feels the need to sort of update the law in this regard. Are you suggesting that, at least from the hospital perspective, you all haven't heard any complaints or any sort of big issues, no big shifts as it relates to radiation equipment and things like that?
Not that we're aware of. I mean, I think the biggest change came with the HORA update with the addition of the licensure requirements for registered technicians, the MRI technicians, and all of that. And I recognize the need to align some of the existing practices with those requirements. But I think we haven't been approached with any issues. And so if there are, we'd love to have a conversation and make sure that there just aren't unintended consequences of the additional licensure that is necessary, because a lot of it is already happening with facilities. And I think the particular concern, at least from some of our members, is that non-ionizing radiation equipment portion.
Right. So, and yeah, you mentioned that as well. I mean, so ionizing radiation equipment is already required in terms of being registered. Have your members experienced any difficulty in sort of dealing with DC Health to go through that process?
Not that I am aware.
Okay.
So, I mean, we haven't heard any complaints about this process or the requirement to register the existing equipment under that is required. So, yeah.
Okay. So, I guess I'm trying to sort of unpack why then a big concern about registering the equipment for non-ionizing radiation.
So I think it'll depend on the process that it requires, like the location. A lot of the ultrasounds will be portable, just like there are portable X-ray machines. So I think it's just making sure that the equipment, the documentation, all of that, is we're tracking the equipment. And I can get more specifics. That was just some of the feedback that we were getting from facilities as we look to what are some of the requirements. I think there's a difference between healthcare facilities like hospitals and individual offices of practitioners that may have this equipment as well. So I think there are two levels of what is the requirement burden for hospitals versus what is the requirement for practitioners that may have some of this equipment as well.
Yeah. I mean, in terms of ultrasounds and sonograms, as you said, it could be a portable equipment, something that's not necessarily stationary. So I understand the desire to make sure that if DC Health were to move forward with this, that it made sense, as opposed to, well, this equipment is tied to this particular room that you all registered as opposed to just the facility in general. Okay.
I think our overall concern is just to have the conversation, because there was no conversation before the introduction. And so I think, we've had some conversations in the last couple of days and want to continue having those conversations with DC Health just to better understand. So yeah.
Okay, that's helpful. Well, I don't have any other questions. Thank you so much, Mr. Palmer. I do wish that we had had some other folks who would sign up to testify for this, because this, outside of the health field, this would certainly impact tanning salons and some others who might not necessarily know.
And that was some of the feedback that we got, because is it focused on medical or non-medical, not particularly for that non-ionizing. So that's a really good point, because I think that was some of the feedback that we got, that it may be, the definition is so broad, it may be impacting people that don't realize it.
Okay. Well, thank you so much, Mr. Palmer. Please make sure you submit your testimony for the record. All right, I will now call up the government witness, Dr. Tai N. Mori, who's the Associate Director of the Office of Food, Radiation, Community Hygiene, and Rodent and Vector Control at DC Health. Dr. Mori, before you begin, I need to swear you in, if you don't mind raising your right hand. All right. Do you swear or affirm under penalty of law that the testimony you're about to provide to the Council of the District of Columbia and this committee is the truth, the whole truth, and nothing but the truth?
Yes.
Awesome. Okay. Please begin.
Good morning, Chairperson Henderson, council members, and staff of the Committee on Health. My name is Dr. Tai Mori, and I am the Associate Director for the Office of Food, Radiation, Community Hygiene, and Rodent and Vector Control within DC Health's Health Regulation and Licensing Administration, HRLA. On behalf of Dr. Ayanna Bennett, Director of DC Health, I am pleased to offer testimony in support of the Radiation Protection Act of 2024. DC Health plays a critical role in advancing the strength and safety of the district's healthcare system, whether it be regulating healthcare facilities, licensing healthcare professionals, creating pathways to the healthcare profession, or ensuring equitable access to healthcare services. DC Health is committed to a modern healthcare system that prioritizes patient safety. This is especially the case for DC Health's Radiation Protection Division, which establishes, implements, and enforces measures and standards to protect people and their environment from the potentially harmful effects of radiation. This division protects patients in the district from the potentially unintended harmful effects of radiation by licensing sources of radiation, registering X-ray producing equipment, inspecting facilities using sources of radiation, responding to and investigating radiation incidents, and conducting surveillance of radiation contamination in the environment. Inspectors of the Radiation Protection Division monitor radiation and radiation emitting equipment in facilities across the district. This is done in collaboration with federal regulators, including the Food and Drug Administration, FDA. As of 2022, DC Health estimates there are 1,151 ionizing equipment, which are higher frequency radiation, such as X-rays, and 176 non-ionizing equipment, which are lower frequency radiation, such as ultrasound imaging, and 1,651 non-governmental businesses and individuals operating in the district that may be impacted by this proposed legislation. These activities are critical to keeping the public safe. However, given the
Dr. Mori? All right, we're going to give it a minute.
Who interact with it across the district.
Dr. Mori, you froze. And so if you want to go back, I don't know, a paragraph.
No worries.
Okay.
Let me start with the Radiation Protection Act of 2024.
Okay.
So the Radiation Protection Act of 2024 will strengthen and modernizes DC Health's oversight of radiation emitting equipment, and the professionals who interact with it across the district. The legislation provides DC Health with new regulatory authority over non-ionizing radiation in its equipment. The Health Occupations Revision General Amendment Act of 2023, currently undergoing congressional review, established licensure under the Board of Medicine for medical radiation technology professionals. It created 9 licenses for medical radiation technology professionals, including radiation therapists, magnetic resonance technologists, MRI, and radiographer. This legislation complements the creation of these licenses by making it clear which activities that involve sources of radiation require licensure. This includes disposing of radiation equipment, operating radiation protection facilities, or using any source of radiation. This bill provides the mayor with new rulemaking authority to protect the public from the unintended harmful cause of non-ionizing radiation. The legislation also clarifies the testing, inspection, and examination authority that DC Health would have for facilities. There's also a clarification for when DC Health can seize, impound, or destroy sources of radiation, waste, or equipment. For example, when a provider engages in cover activities without being properly licensed, certified, registered, or accredited. Similarly, the bill allows the district to take civil and criminal action against those who violate radiation protection laws and regulations. While DC Health has taken an active role in the regulating of radiation, this has often relied on existing federal regulations under the Centers for Medicare and Medicaid Services, which apply to most healthcare providers in the district. Separately, the FDA has oversight of all radiation emitting devices in the medical setting nationwide. The Radiation Protection Act of 2024 brings the district radiation laws and regulations in line with modern radiation practices. Under current district law, DC Health does not have the authority to regulate the use of non-ionizing radiation. Non-ionizing radiation is used in a variety of imaging technologies, including MRIs and ultrasounds. These technologies are significantly across healthcare. For example, roughly 40 million MRI scans are performed each year in the United States. MRI technology has seen a significant increase in use, with approximately a doubling in the numbers of scans performed between the years of 2000 and 2016. This legislation will ensure that DC Health does not need to rely on federal requirements to regulate the common medical diagnostic tool. This is especially important as we may see non-federally regulated facilities seek to incorporate non-ionizing technologies into their practices. Several other jurisdictions across the country has moved to regulate non-ionizing radiation, including Massachusetts and Arizona. This legislation provides DC Health with the ability to adapt to advances in medical radiation technology that will maintain the district position nationwide as a leading healthcare system. The Radiation Protection Division has used these federal regulations to ensure compliance across the district. This is achieved through biannual facility surveys, which can identify non-compliant radiation devices. While no issues have arisen, it poses a potential risk to patients and healthcare professionals should a provider choose not to voluntarily comply. This highlights the importance of enhanced enforcement authority at the district level. This will allow DC Health to take more comprehensive disciplinary action should any issues arise. This is important not only in the context of patient safety, but also to protect members of our healthcare workforce who directly radiation emitting devices. Radiation professionals, including Maryland and Virginia. This increased oversight of both professionals to work with either non-ionizing or ionizing devices will enhance patient safety, will also improve quality of care by ensuring that people who interact with radiation emitting devices have the appropriate training and experience to do so. In summary, DC Health strongly supports this legislation as we seek to advance the district's healthcare system. We appreciate the opportunity to discuss the importance of modern radiation laws and regulations and the ways in which it will strengthen patient safety and improve the quality of care in the district. Thank you for providing me with the opportunity to testify, and I am available to respond to any questions the committee may have.
Thank you so much, Dr. Morey, for your testimony. I do have a few follow-up questions. So you described in your testimony DC Health's role in protecting the public from dangers to human health related to radiation. Can you provide some examples in the past or in the present of misuse of radioactive material or equipment we've had here in DC?
So from what I'm aware, there have not been any issue of misuse of radiation. And speaking with my colleagues and the team in radiation, there has not been any intended harmful effects within the past several decades.
Okay. All right. So can you say a little bit more in terms of why DC Health has decided that they want to start regulating non-ionizing radiation for the first time? And I mean, with that, and this kind of came up in the conversation with Justin Palmer, the definition is quite broad. So are you all intending to regulate devices that are not medical, like tanning beds? Was that the intent?
So the purpose of this bill is to regulate non-ionizing equipment such as MRIs and ultrasound. As to why we're doing now, we're currently acting on the behalf of FDA regulations, and we want that primary authority. We work in these spaces on a daily basis. So it just extremely helpful and logical for us to be proactive and be the primary regulatory of this. As in regulating tanning beds, we currently, under the Radiation Protection Division, currently do regulate tanning beds. We go out and do inspections.
Okay, so there is the intent for you all, for DC Health, to be able to do all non-ionizing radiation equipment, including non-medical related.
Correct.
Okay. And
but I just want to clarify, not necessarily all, but some.
Say more.
For example, not exclusively medical. I realize there's some discussion regarding telecommunication, but more like research and academic areas.
Oh, I see. Okay. Okay. I got it. All right. Now, you mentioned just very briefly that this was, I guess, a reaction to something from the FDA. Can you say more about that?
So we regulate based on FDA requirements. What we do when we go in and inspect our ionizing, for non-ionizing, we act on behalf of the FDA by using their standards and regulations. What we're looking for through this bill, we want to be the primary regulatory authority. We have reporting authority, but not the regulatory authority.
Okay. So there is not a requirement from FDA that jurisdictions look at non-ionizing devices?
No, not to my knowledge.
Okay. Are there any shortcomings in the FDA regulations that you all feel like they're no longer good enough, or there's now a desire that DC have its own standard?
I feel we will be faster in responding to any incidents that should occur. compared to FDA.
Okay. I want to ask some questions specifically about some of the definitions that we have in the bill. So apologies for the public, this is a bit technical in nature, but several of the terms defined in the bill as introduced are also defined in the most recently approved HORA, such as medical radiation technology, radiation therapy technology, and nuclear medicine technology. Was this bill drafted with the new definitions that are in the HORA in mind, or was this bill drafted before the HORA?
It was drafted before the HORA.
Okay, so would you all be okay if we instead tied, we use the existing definitions that we just passed as opposed to these new definitions?
Yes, we are amenable to the new definitions.
Okay. All right, hold on. Okay. As you mentioned in your testimony, the most recently approved HORA contained some new types of health professions that are also included in this bill. You testify that this bill is complementary, but in some cases they are conflicting. And so we just want to ask about a couple of them. So for instance, this bill regulates radiation therapy technologists, while the HORA regulates radiation therapists. Are these two different licenses?
No, they're not two different licenses. We feel this bill is complementary to the HORA, to the individuals working in the field. The additional professions is more that we acknowledge in the bill. If I may confer with my team and we can get back with you to a more detailed answer after hearing.
Okay. So there are a couple others that I'll just mention for the record that we want to get some clarification on. So this bill regulates a medical radiographer, while the HORA regulates just a radiographer. And so we want to know, are those two licenses intended to be different? And if they are, what are the differences? And then both bills regulate a nuclear medicine technologist rather, and a radiologist assistant. And then we're curious in terms of why is it necessary to require licensure for these two separate parts of the code as well? So we could send a follow-up list. Basically, we want to make sure that the bills conform and that we're not passing conflicting information for a bill that we just did, if that makes sense.
We'll definitely get back with you.
Okay. Okay, so during our work on the HORA, the committee heard from the Society of Diagnostic Medical Sonography that had several concerns that unfortunately, due to timing, we were not able to incorporate into the HORA. However, they seem very germane to this legislation. So first, the SDMS suggested changing all mentions of medical radiation technology to medical imaging and radiation therapy. Does DC Health have a specific position on this change of terminology?
Sorry.
It's okay.
We will address it with the advisory committee and let you know the regulations.
Okay, but this isn't something that would be reg. This was something that would need to be changed in code. So we would need a different type of conversation on that. The other thing is that they advocated for changing the term ultrasound technologist to sonographer. And we were curious if DC Health has any oppositions to that change of terminology as well. They say that it's more updated. Like ultrasound tech is not something that's necessarily used in terminology today.
Chairperson Hendrick, is okay. Let me confirm with my team. We get back with you to the answer. I just want to get more information on the new advisory committee.
Okay. All right. So the bill gives the mayor authority to issue a wide range of regulations or requirements, but DC Health has already has regulations on several of these topics. So some of them including like registration of radiation machine facilities, licensure of associated healthcare professionals, licensing of radioactive material. Why is DC Health proposing codifying the mayor's authority to issue these regulations if some of them already exist?
Again, the purpose of this bill is to regulate the non-ionizing equipment such as MRIs and ultrasound. Currently, we are acting on behalf of FDA. Again, we would like to be the primary regulatory of these equipment.
I know I understand what you say the purpose of the bill is. What I'm saying is that there are some duplicative pieces that you all have included, and we're trying to understand why.
This bill doesn't amend the HOR at all. What does this bill do?
No, I know it doesn't amend the HOR. What I'm saying is that you all already have these regulations for some of these things. And so that's where we're just trying to understand, why are you giving the mayor authority to regulate something she already regulates? That's all I'm asking.
The codification makes it a little bit more clear within this bill. We're just updating, excuse me for a second. We're just updating the regulations that we currently have to new authority making.
Okay, I'm still not clear on why I need to give the mayor authority to regulate something she already regulates.
Allow us to get back with you for a detailed answer in writing right after this hearing.
Okay. Okay. So, the bill authorizes the mayor to establish requirements for licensure, certification, or registration for individuals involved in medication, radiation technology, or radiation therapy technology, the suppliers, and the portable X-ray service providers. Why do we feel it's important that we need a licensure for suppliers and service providers?
I am going to defer to Dr. Gregory Talley, who's the program manager of the Radiation Protection Department, who's also a trained health physicist by license.
Good afternoon. Good morning. Do I need to get sworn in, or are you going to trust my my testimony?
I'm gonna trust you.
You're going to trust me.
I didn't know that you were in the room, or I would have swore you in at the beginning.
Oh, well, I was trying to be in the background. You probably heard me whispering.
Okay. Can you mention your name again? Just
okay.
For the
first name is Gregory. Last name is Talley, and I'm the program manager for the Radiation Protection Division.
Okay.
Dr. Ty, of course, is my supervisor. When I first joined here many years ago, we had problems keeping track of the radiation producing equipment that came into the city or left the city. So we implemented a requirement that manufacturers or suppliers of radiation producing equipment must be licensed. So if they did not follow our regulations, we could prohibit them from providing the equipment in the city. So this is simple as it. Okay, so for the radiation equipment manufacturers or suppliers, and they are licensed annually.
Okay. And so as you mentioned, you all already require medical suppliers and the servicers to be licensed. So why are you proposing to codify this authority if you've already issued regulations on it?
We're basically just updating our regulations. The regulations were last promulgated in, I think it was like 1989, something like that. So that's why, I mean, we're talking about something that's almost 40 years old. So that's really why we are now updating these regulations. So the requirements for the technical aspect of the equipment, an X-ray is an X-ray is an X-ray.
Mhm.
Okay, but we needed to update our regulations. And as you heard in Dr. Todd's testimony, the current regs didn't even include MRI. So that's the reason why we are now bringing it to the council's consideration for approval of the updated regs.
Okay. This bill would repeal the district's low-level radioactive waste generator regulatory policy act of 1990. Is it DC Health's intent that this new legislation will replace the requirements from this 1990 law?
Yes. There was a requirement at one time, according to the volume of low-level radioactive waste that was generated in the country, that there were compacts that were established. And in these compacts, there was a radioactive waste depository, basically a dump for this material. And there was a fee associated with it. So the District of Columbia government established a $5,000 fee for all generators of this waste that had to go to this repository. Our particular repository was in Barnwell, South Carolina. Well, because of the state of the art now, we don't generate that volume of waste anymore. So we don't need that law. So that's why we are repealing the law.
Got it. All right, Mr. Talley, I feel like you the expert here.
Okay. Now, that means a lot coming from you, Councilman.
On all of this. That. Okay, so you said the current registration fee was $5,000, but that we basically haven't been collecting this. Is that correct?
That's correct.
All right. So we will remember this if the CFO comes back and tells us that there is a financial impact to this bill for us repealing this fee.
Yes,
the 1990 law also required an annual report detailing, the disposal of the waste. Will these annual reports still be required or no?
No.
Okay. And then, is there any type of reporting that you feel like this new legislation should require?
There is a report that is required. Well, I'm going to say right now, no. I'd have to get back to you on that because I'd have to check with my supervisors. But at my level, there's not an annual report that needs to be submitted to anyone other than my director, of course.
Okay. All right. Wow, that's interesting. So our place was Barnwell, South Carolina. And I'm saying this as a person who went to college in South Carolina.
Yes, ma'am.
Yeah, that the district was sending our waste.
Everyone in the compact. Yes, it was, the New England states, Maryland, Virginia, Delaware. Yes, ma'am.
Interesting. Okay. So for facilities that are currently subject to DC Health's radiation regulations, what would change about their process for being licensed? Like, what do you anticipate as an additional? Are there any additional burdens that will be on those facilities based on this new law?
No changes at all, except hopefully the approval of the licensure requirement for individuals that operate radiation producing equipment. Now, the hospitals cover that, but we have a lot of, in fact, I think Dr. Ty gave you the actual number of private facilities, these private dental offices and the medical offices. This will have an impact on the individuals that operate the radiation producing equipment.
Okay, so for dental x-rays and those
yes, ma'am.
Okay.
Yes,
all right. Okay. We probably we are probably going to have to follow up with you on that, just in terms of, I know that we just made some changes, the HORA, around what dental assistants can and cannot do in the office setting. And I just want to make sure that we haven't just given them an expanded authority only for us to be taking it back by saying, actually, if you do x-rays as a dental assistant, now you need to get an additional licensure in order to do so. Okay. Would facilities be required to get each piece of equipment registered in addition to their facility license registration?
Yes, that's currently the law. Yes, that hasn't changed.
Okay. What's the benefit of us requiring each piece of equipment to be registered?
We are mandated by the mayor to have accountability for all sources of radiation in the city. And my division has that responsibility of providing that information, such as in what Dr. Ty gave you earlier in terms of the numbers, of ionizing radiation producing equipment.
Yeah. So I mean, I think that's if we could go back to that for a second, in like the most basic way that you can explain it for the public, why is it important that DC Health now began regulating non-ionizing radiation equipment?
I watch the council hearings almost daily. In fact, I probably get in trouble from my supervisors for listening to the hearings in background. And I think you are a mother. I would imagine you would have concerns if your child were to undergo an MRI and that device was not regulated. Our mandate is to assure that individuals, visitors, and residents of the District of Columbia are protected from the hazards of radiation exposure. That's what we mandated to do. And if I don't have the authority to oversee a non-ionizing piece of equipment, such as an ultrasound or an MRI, I mean, it's no telling what hazards could be presented to not only your children, but to you. So that's why we need to be able to regulate this equipment. Right now, if there was some malfunctioning equipment, we don't have the authority. DC Health does not have the authority to do anything pertaining to that device. Now, as Dr. Ty indicated, we use a back door and use the FDA requirements, but we need to have that authority, the district government, just as simple as that.
Well, I can't argue with that as a particular reason. Okay. Is there anything we have a couple of things that we're gonna certainly follow up with you on, particularly as I talked about we just want to make sure we don't have conflicting definitions between what's in this legislation versus what's in the HORA that we just passed. And so we're gonna send some follow-up questions.
Okay, I'm gonna yield back to Dr. Ty.
Dr. DC Health on that. Okay. Well, actually, Mr. Talley, if you can come back just for a second, I just have one specific question. So we did get testimony, although they didn't present it today, from the Society of Diagnostic Medical Sonography. And they this was the question or something that they said, which is, why are you all proposing to regulate ultrasound and sonography? They submitted testimony that said that ultrasound does not involve any form of radiation. Do you agree with that statement?
Ultrasound involves non-ionizing radiation. Okay. So the statement that it doesn't involve radiation, well, as you very clearly indicated in your introduction, you have two types of radiation, ionizing and non-ionizing. And sonography is non-ionizing radiation. Again, I have to kind of defer back to you a little bit. Again, you are a mother, so when you were going through the pre-birth activities, you underwent a procedure using an ultrasound device. I would hope you would have been concerned that that device was operating properly. And right now, we don't have the oversight to assure that.
Okay. All right. Thank you. So we'll definitely follow up with DC Health on all the things in terms of this legislation. As I mentioned at the beginning, the committee will mark up the 2 nominations tomorrow. I want to thank all the witnesses who testified today. The record for this bill will remain open until 5 p.m. on July 24th for the public to submit testimony. You may submit your written statements via the council's hearing management system website at dccouncil.gov/hearings. The next Committee on Health hearing will be tomorrow, July 11th. We will consider 2 nominations to the Board of Dentistry, as well as 3 bills. Bill 25-759, the Child Behavioral Health Services Dashboard Act of 2024. Bill 25-692, Enhancing Mental Health Crisis Support and Hospitalization Amendment Act of 2024, and Bill 25-696, Advancing the Range of Reproductive Options for Washingtonians Amendment Act of 2024. Thank you so much, Dr. Morey, and to your team. The time is now 10:40 a.m. and this hearing is adjourned. Thank you.
Thank you.